How so?
Something, right? Let me precede my comments with this, that we should all be interested in getting institutions of state work properly. Let me just say this. I say this order is not proper because, one, the special prosecutor or the office of the special prosecutor and the accused person definitely will have a dispute about the date of seizure. The date of seizure. Now, if the office of the special prosecutor is still operating or is still in the process of searching and confiscation, are we to understand that at every instant, every second or minute, that it discovers something belonging to the accused person and seizes it, then the time for which or within which it has to apply to the court for confirmation starts from then? Or we are looking at a comprehensive or complete, or the time when the OSP has completed its search and discovery or seizure of everything within the operation. Now, secondly, you will also notice that when a property is seized, there is a provision under the OSP's Act that provides for the management of that property. Now, if an application is made, my question is, if an application is made for confirmation of seizure, is it an opportunity for the court to refuse the application and order a return of the property to the accused person? Because for me, if you look at the Act properly, the two are completely distinct. Before the court can return the property to the accused person, it is an application, it must be upon an application made by the accused person alleging certain things itemized under the law. So if the OSP goes to court and said, okay, I have confiscated this thing, it is in relation to someone who I am investigating for corruption or against whom corruption charges are leveled, and the property is tainted, I have reasonable grounds to believe that the property is tainted, then you refuse to confirm the order. For me, I think it should have stopped there for the accused person to make the application under the relevant provision and now produce evidence for the things that are supposed to be proven under that provision, that the property is not tainted, that she has no interest in that property, or that, these are the grounds that must be proven for the property to return. And for me, for the court to return the property without going this deep to make this distinction is wrong. Secondly, I look at the impression the courts are giving to the citizenry about the fight against corruption. Now, this is a public officer, and we all know that by law or under law, especially the Public Financial Administration Act, a minister of state manages public funds. So if a minister of state is under a duty to manage public funds, and under the Constitution is not supposed to place him or herself in a position in which his private things conflict with his duty or functions in that public office. Now, if this quantum of money is found in the private room, not in the bank account, of a public person or a minister who is supposed to manage public funds, would it be a reasonable ground for an OSP to think that this property, which is in his custody, in her custody, is tainted? That is the question the court probably would have to answer. Because if you want to come to the conclusion that there's reasonable grounds that the property is tainted or not, then of course you have to go through this process. What is the reasonability of the charge or the investigation? And then you go to the seizure, the account. The account. Now, the application made in respect of the account is also in a separate and distinct provision within the Act. Now, if what need be proven there? That, look, the person is being investigated for corruption-related offenses, is being charged, and again, that there is reasonable grounds that the property or the account, what is in the account is tainted. So for me, I am interested in how the court gets to the conclusion that the property is not tainted or there is no reasonable grounds for the property to be seized.
I see. Were you referring to, I want to look for this particular section of the OSP law, freezing of property,
Yes.
section 38. It says, where the special prosecutor considers that freezing of property is necessary to facilitate an investigation, or prosecution, the special prosecutor shall in writing direct the freezing of the property of a person or entity being investigated. So when you said if you are being investigated, is that enough to hold the money? If you get to section 40, it says issuing of freezing orders. It says where an application is made for a freezing order, the court shall issue the order if it is satisfied that A, the respondent is being investigated for corruption or corruption-related offenses. The respondent, B, is charged with corruption or corruption-related offenses. What will be the justice if the person is only being investigated, they have not been charged, and you are seizing their property? Don't you see that's where the court is thinking? That it's not fair, human rights?
Samson. So are we saying that there was no charge yet?
No, there's no charge. There's investigation that is ongoing.
Okay. So if there is investigation that's ongoing, and there is a reasonable grounds for the OSP to believe that the property of the person being investigated in relation to corruption-related offenses are tainted, shouldn't that be the grounds sufficient for the OSP to seize the property? Because it is not about the charge. The charge actually is to be leveled and determined in a separate proceedings. These are preliminary measures to ensure that the property in respect of which the OSP is prosecuting or is taking steps or action is not lost, is not dissipated. And sometimes it is supposed to accord the special prosecutor evidence for what it is doing. And so if, for me, the basic...
Okay, I'm losing Osman there. I can move on to someone else, but I'd like to...
If there is reasonable grounds based on which the special prosecutor can come to the conclusion that the property of the accused person is tainted.
Okay.
And so, yes.
Quickly explain this again for me, very briefly. What do you mean by the seizure of the money is separate and distinct from the freezing of the account. You were referring to the Act again, or the LI, and I'm looking at the seizure of money. It does appear that once they seize the money, and you, the person whose money has been seized, you don't take certain steps within, I think it's a month, you lose the money, you forfeit it. And it appears that by the time the court was giving this ruling, the 1 month has already elapsed, and the Cecilia Dapaah had not gone to seek to get this money back. So that's another legal situation that occurs, right?
Of course. You see, so that's why I said it is up to the person, the accused person, to also make an application and prove certain things that the court must determine before a return of the property. And so there's a time, as you said, there's a time limit given within the Act for this to happen. And if the time runs, counting from the date of the seizure, then, of course, she loses the right to now go and apply for the return of the property.
So now that the court has said, unfreeze the money and return the money you seized, and the ruling is coming late at a date when the period when she should have gone to ask for the money has elapsed according to the law, do you see that there's some legal, tussle that will ensue?
Hey, Samson, that's why I said these are preliminary stages. The substantive action itself is to be tried and determined in the criminal proceedings. So I believe that the criminal court that is presenting over the substantive matter, upon determining that she is not guilty of the corruption, it can order that the property be returned to her. And so that's why I said, if you look at the way the property should be managed,
so,
in fact, it's even include, yes.
So my final question to you, and I want a very brief answer, but before that, I want to read the OSP's response. It says that the Office of the Special Prosecutor commenced investigations in the 3rd week of July 2023 in respect of the suspected corruption and corruption-related offenses regarding large amounts of money and other valuable items involving Ms. Cecilia Dapaah, a former Minister of Sanitation and Water Resources. When he says they commence investigation, it seems to reply to the court that when you suggest that we are not doing any investigation, you are wrong. We are actually investigating. Then it says on the 31st of August 2023, the High Court, Accra, refused to grant the application of the seizure and freezing orders on the grounds that the confiscation of seizure application was filed out of time, that the OSP did not provide any basis for the seizure and the freezing since it did not disclose the details of the transactions in the accounts. And further, that the freezing order was based on public sentiments and without proper investigation. While the OSP respects the court's decision, it disagrees with the decision of the court. First, the OSP believes that the court's computation of the time limitation is, with respect, erroneous. The OSP searched 3 private residences associated with Ms. Dapaah over the course of 2 weeks. The searches and discovery were ongoing during that period. There is little doubt that the OSP filed its application within the statutory window once the search and discovery window is considered. Second, the seizure by the OSP and the Special Prosecutor's freezing order were effectuated on the very firm basis of reasonable suspicion that the amounts and bank balances were tainted property, as Ms. Dapaah prevaricated as to the source or sources of the amounts she reported stolen from the residence, the amounts discovered by the OSP in her residence, and the volume of transactions in her bank accounts and investment. Third, the freezing order was not based on public sentiment. Rather, it was based on court processes filed in a criminal matter before the circuit court. Accra, involving Ms. Dapaah as a complainant. Further, the freezing order was effected to aid the investigation as required by law, not on the basis of the investigation, as indicated by the court. Therefore, it cannot be said that the OSP did not carry out proper investigation to warrant the freezing order. The investigation has only commenced and it is ongoing. The OSP, that's the last point I ask you the question on. The OSP assures the public that it will take all necessary legal steps to ensure that the seizure amounts and the balances in Ms. Dapaah's bank accounts and investments are neither concealed, lost, or otherwise dissipated. What is he saying he's going to do?
Well, perhaps appeal against the decision of the High Court and still withhold the funds as seized, and probably apply to the Court of Appeal to hold off the implementation of the High Court's order to return the properties to the woman. That's the only way I'm looking at it.
But it has their administrative power to continue to freeze their monies, right?
That's why I'm saying upon appeal, if there is an appeal and they file an application for an injunction to restrain the